Greetings everyone, welcome to my YouTube channel. If you are here for the first time, I am Advocate Pule Matsilo. The purpose of this channel is to teach South African law and also to teach the Word of God. Today, I will be teaching South African law on the topic unfair labor practices. Now, I will introduce the topic. I will define the concept, or rather state factors which qualify as unfair labor practice, and I will indicate to you the solution that you should do, and I will close. As a way of introducing my topic, today we know that there are so many challenges in the workplace, and there are so many, or let me rather say there are few legislations that govern employer-employee relationship. But today I will focus on one of them when I discuss this topic, unfair labor practices. The key legislation here is Labor Relations Act. We will focus on Section 186, subsection 2, because that is the primary section that governs this particular topic. But let me start by saying, you know, the workplace, it's a place where you spend 8 hours of your day. If you are in South Africa, I don't know about other countries. And this is the day where for most people, you spend 5 days of your week. For some people, even more. I know that there are debates, there are talks. I've been reading articles where they talk about the fact that they are trying or they are considering to make South Africa a 4-day workplace. But there are some who even work at night. There are some who even work for 7 days straight. There are for some people that sometimes they don't even get an off, unfortunately, Monday to Sunday. And this is a place where you're supposed to enjoy yourself. This is a place, the workplace is a place where you have to look forward to go to your work. But unfortunately, for some people, it is a place of misery. People have got no option but to go. Why? Because you are not financially independent. Because you have to put bread on the table. And some people, they even make this purposely hostile as a way of pushing you out of the system. That is why last time we spoke about constructive dismissal. But today we're not talking about constructive dismissal. When you look at Section 185, Section 185 says that everyone has the right to be treated fairly at work. This is so that you should enjoy your rights which are enshrined in the Constitution. Section 23 thereof, which says everyone has the right to fair labor practices. So the law in the Labor Relations Act, Section 185 says everyone has the right to be treated fairly. Now the question is, when can we say a person is not treated fairly? What are unfair labor practices? As I started earlier on, these unfair labor practices are contained in Section 186, subsection 2 of the Labor Relations Act. So, for you to define or to determine whether there is an unfair labor practice, you look at this section and at the subsection, to be specific, of the Labor Relations Act. You look at it. If it's anything that falls outside the scope of the definition or the explanation or the meaning contained in the Section 186, subsection 2, then it will be something else. Now, what does this section say? In some instances, I will read and unpack the meaning of the section. The section says, unfair labor practice, because it is unfair. And let me start by mentioning that this unfairness that we are talking about can be substantive or can be procedural. You can talk about an unfair labor practice because it's substantive or it's procedural, but we will not focus on that today. The main focus will be what is unfair labor practice. It starts by saying any unfair act or omission that arise from employer-employee relationship. Any act. You know, in law, when they talk about an act, it's something that you have done. And then it says any act or omission. When it talks about an omission, it's something that you haven't done. So it's something that you have failed to do. So even if you did not do it, even if it's because you failed to do it, it will be an unfair labor practice. And this unfair act or omission, it must arise from an employer and employee relationship. So you must be employed by this person. You must be an employee of this company for us to even begin to check whether it's unfair labor practice. And when we talk about an employer here, we're talking about the management of a company, the management of a place of work represent the employer. Not people on the same level as you, not your juniors. If there is any unfair act or omission by any of them, if they are not in management position, they do not represent the employer. So there must be that relationship. It must be an act and omission arising out of that relationship. You cannot talk about something that happened in the past. You used to be. There must be a relationship. An employer and employee relationship. So what are these acts that constitute unfair labor practice? Number one, it's promotion, demotion, probation, training, provision of benefits. Now, let us explain them one by one. What about promotion? Let's say you are working for this company, as we have illustrated that there must be that employer-employee relationship, and you are not promoted. You have the necessary skills. You have necessary expertise. You have the necessary qualification. You are being overlooked. That act can constitute unfair labor practice as long as you are able to prove it. The second one is a demotion. When you are being unfairly demoted. By the way, there are instances where demotion can be lawful. For example, if they are busy restructuring and they are trying to keep some people in, and maybe that post can keep you in, or in cases where for some reason you fell ill, you are being incapacitated, they are trying to retain you and you are no longer able to perform in that position. But I also need to emphasize that every case will be treated according to it. If you are unlawfully demoted, not when demotion is used as punishment, whereby maybe you committed an act and you were disciplinary charged, and as punishment, you were demoted instead of being dismissed. That one is different. But when a demotion cannot be legally justified, it constitutes unfair labor practice. The other one is probation. We all know that in most instances, probation will be 1 year, maybe some instances 3 months. If after a year, they keep on extending it, or they fire you for no justification, or they just keep on extending it, or nobody comes back to you to say, we are assessing you, we are checking whether you qualify to be appointed permanently. That will be unfair labor practice. The other one is training. When you are employed in a company, you are expected to be trained for that position. Even if you have been trained and qualified, there is what is called continuous development. From time to time, the employer must expose you to training that will make you to excel even more. So training is a requirement for your job. Because you must remember there may be instances where the employer can say, you are not performing. Are they going to dismiss you? No. They cannot just dismiss you and say you are not performing. They'll have to prove what is it that they have done before they even think of dismissing you. What is it that they have done to assist in improving you? Because you must remember, somebody says dismissal in labor law or in labor matters is regarded as the death penalty. In other words, it's the last thing that you want to do. You don't just start by dismissing people. And I'm not suggesting that there are offenses that are not. There are some offenses that are outright dismissible offenses. But I'm talking about those minor offenses whereby a person can be given a chance to say, okay, you are not performing, let's try this, let's give you mentoring, let's give you training and give you a chance. So training, it's mandatory. And therefore, if it's not awarded to you, if you're not given that chance, other people are allowed to go for this training and this training, but you're always overlooked. It can be unfair labor practice. The other one is provision of benefits. If all of a sudden the employer decides to withdraw some benefits, which you used to be entitled to, or which you are entitled to, which you are supposed to be given, and all of a sudden there is a withdrawal, or you are not even given those benefits, and they're supposed to be part of your package, that can result in unfair labor practice. The other one is unfair suspension. I said it can be procedural or it can be substantive. When a person is suspended, it has to be done legally. There is the correct way of suspending a person. You can't just come to a person today and call them into an office and say, we are suspending you. There's a process, there's a procedure that must be followed first before a person is suspended. We'll discuss it at a later stage. And this suspension, if it's precautionary suspension, it must be with a salary. Because the reason why you are suspended is maybe because they think that you will interfere with witnesses. So they are removing you so that maybe you should not destroy evidence. Those are just a few of the examples why they can give you a precautionary suspension. If that is the reason, now it must be done with a salary. But if it's suspension, which is a punishment, you were disciplinary charged, you were trialed, you were found guilty, and then they give you suspension as a sentence or as punishment, there you don't have to be paid. But if it's precautionary suspension, you have to be paid. And if you are not paid, if it's not done procedurally in a correct manner, that can constitute unfair labor practice. The other one is refusal to reinstate where there was an agreement. There are instances where a person can be dismissed, for lack of a better word. That's why I'm doing this. You are maybe dismissed, you found yourself out. There may be some negotiations, maybe with the union, that, okay, let there be a re-employment, let people be reinstated. But the employer still refuses to reinstate you, despite the fact that there was an agreement to that effect. That will constitute unfair labor practice. The fourth one, it's an occupational detriment, which is suffered by an employee, despite the fact that the employee is protected by the Protected Disclosure Act. Let me explain this. There are some instances where you disclose some information, maybe of corruption, of some criminal activity going on, nepotism, things that happen that are illegal in the workplace. And this act, Protection of Disclosure Act, protects you that if you can whistleblow, we call people like that whistleblowers. If you whistleblow, you are protected in terms of this act. So there are instances where the employer can decide to put you through hell, to vilify you, just because of you disclosing that fact. They can decide to ill-treat you, to treat you bad, to vilify you because of that. That may be an unfair labor practice. Now, after saying this, after mentioning these factors that constitute unfair labor practice, we need to realize that this list in section 186 subsection 2 is a closed list. In other words, anything that does not fall within this category cannot be regarded as unfair labor practice. So you'll have to find out, to go through the act and check where your concern falls, because it will not necessarily be covered by this particular section that we have just discussed. Now the question is, when you find yourself in this position where you have established that indeed your challenge, your problem falls within section 186 subsection 2, what do? You approach CCMA. You approach the bargaining council. You approach the labor court. If you decide to approach CCMA, which is Commission for Conciliation, Mediation, and Arbitration, you go to their website. There is a form that you fill there. It's called Form 711. You lodged your complaint there in that form. By the way, these days, you can lodge your complaint online if you are technologically savvy. You lodge that complaint there. The form is very user-friendly. You write down your complaint there with the details that are required in the form that you will get from their website. And you lodge your complaint with the CCMA, and you must also serve the employer, because they must also know that this is the step that you have decided to take against them regarding that situation. Because you must remember, they will also be expected to come and appear. Because in law, there's a principle that, I won't say the Latin word for now, but there's a principle that says before you decide, you have to go to hear both sides of the story. So it will be your side of the story, the other side would be the side of the employer. So you must also know that it is very important that you should speedily submit your complaint, lodge your complaint speedily, because you have to do it within 90 days. In the legal forum, they work with timelines. You can't stay forever and say, oh, at such and such a time, me, since I started working here, I've always been, like I've been here for 5 years. This is what they've been doing since the first year. Well, you can refer to your first year as a way of corroborating your story. But the most important thing in terms of the timeline is for you to be able to establish that that complaint that you have lodged, it's within 90 days since you have come to a conclusion that there is an unfair labor practice against you. There are timelines for everything. Like for dismissal, within 30 days, if you feel it's unfair, you have to lodge. If it's sexual misconduct against you, there are also timelines within which you have to lodge. Because if you don't lodge within that time period, within that time frame, your claim would have expired. But I'm not saying this to discourage you to say you can't continue. There are instances where you can lodge it even if you are late, but you can prepare a condonation to say, maybe I didn't know, I don't know what your reasons would be, but it's very important that you stick to your time frames so that your claim can be successfully lodged. I hope you find this helpful. We are very lucky in South Africa because we live in a constitutional democracy where our rights are enshrined in the Constitution, Section 23, and there are many progressive pieces of legislation that we also have. Today, we focused on the Labor Relations Act. I thank you. Please don't forget to comment, to even subscribe, and press the post notification bell so that whenever we upload, you get to be notified. Thank you very much. I want to thank all of you for supporting my YouTube channel. God bless you.